Just to give a quick outline of our presentation, I'll begin by discussing the Fair Credit Reporting Act application to background checks. I'll follow that with discussion of the Pennsylvania statute and the City of Philadelphia ordinance that regulate an employer's use of criminal history information, and talk about the EEOC's take on employers' use of criminal history and credit history in the hiring process. Meredith will then take over with the review of some of the rules governing pre-employment medical inquiries and drug and alcohol screening. And finally, Meredith will discuss the positive and negative aspects of employers' access to employee information on the Internet and the use of that information in the hiring process. So to start, the Fair Credit Reporting Act, or FCRA, is the federal statute that governs the use of consumer reports for an employment purpose. And both terms, consumer reports and employment purpose, are specifically defined in the FCRA. It's important that you know that the FCRA imposes procedural requirements on an employer who engages a third party to conduct a consumer report. So what is a consumer report? The FCRA includes a broad definition of consumer report. Reports include criminal background checks, credit checks, driving record histories, educational, personal, and employment background investigations. It also includes net and social media checks like reviewing an applicant's Facebook profile, Twitter account, or LinkedIn account. One unique and important aspect of the FCRA is that the FCRA's requirements are only triggered by investigations that are performed by third parties. Investigations conducted by the employer itself do not trigger the FCRA requirements, but they do, as the slide says, raise various other employment considerations. Especially if the employer engages a third party to conduct an investigation of an applicant, and that includes asking another agency to provide a credit report or to run and provide a criminal history report. Those requests and those reports would be covered by the FCRA requirements, but if the employers, if employees in the employer's human resources department and run those types of investigations, if they look at employees' Facebook accounts or review employees' Twitter posts, those would not be covered by the FCRA's requirements. The next slide defines an employment purpose. Employment purpose is really broadly defined in FCRA, and it clearly covers screening applicants for employment. Get specific requirements on employers who engage third parties to provide consumer reports. There are 5 requirements, and through each detail. Some of the requirements do seem redundant, but it's important to note that many of them are truly separate requirements, specifically the last 2 that I'll get to. The provision of a report and notice of intent to take adverse action and the notice of adverse action do have to be separate notices to employees. The requirement is written disclosure to an applicant that a consumer report will be obtained. That disclosure needs to be clear and conspicuous, and it cannot be a job application, an employee handbook, or a similar document. It has to be a separate notification to the employee that the employer intends to obtain a consumer report. The next requirement is written authorization. The employer, after giving notice to an employee that it will seek and obtain a consumer report, employee's written authorization, or the applicant's written authorization to conduct that, to obtain the consumer report, to check the employee's credit, to run a criminal history search. This is like the last 2 requirements, requirements 4 and 5 that we'll get to in a moment. The written authorization can be on the same form that gave the employee notice that the consumer report would be obtained. So essentially, you can give the employee notice that you'll obtain a consumer report, and at the same time ask the employee to sign off on that form, given the employee's authorization. Requirement 3 is certification to the credit reporting agency. Essentially, that is what it sounds sounds like. The employer has to certify to the credit reporting agency that it has made a disclosure to the applicant and received the applicant's authorization to obtain a credit report, that the information being obtained will not be used in violation of any federal or state EEO laws or regulations, and if an adverse action is to be taken based on the consumer report, a copy of the report and a summary of the consumer's rights, the applicant's rights, will be provided to the applicant. It's the significant step that carries through the next steps. If employer is going to run background checks or going to engage a third party to run background checks of applicants, you should only do so with the knowledge that if you make a decision not to hire that applicant based on the results of the credit report, both the report itself and the fact that you made a decision based on the credit report have to be disclosed to the applicant. Requirement 4 is provision of the report and notice of the intent to take adverse action. Before an employer takes adverse action based on information in the consumer report, which if of a job applicant would be refusal to hire the applicant, the employer is required to provide the applicant with notice of the intent not to hire the applicant based on information in the report. The employer is also required to provide a copy of the report and a statement of the individual's rights under the FCRA. You'll see slide that the summary of the consumer or the applicant's rights is available on the FTC's website. Website address. The web address is there on the screen. The requirement is note of the adverse action. The notice of adverse action, well, this one significant point about this is that the notice of adverse action has to be a separate notice from the notice of intent to take adverse action. And I know that seems counterintuitive, but it is important that you meet both of these requirements if you engage a third party to run a consumer report. Notice of adverse action must state that the adverse action was taken based on the consumer report. It include contact information for the consumer reporting agency. It include a statement the consumer reporting agency did not make the adverse decision and cannot explain why the decision was made. It must explain the employee applicant's rights under the FCRA to obtain a free copy of the consumer report from the consumer reporting agency and dispute with the agency the accuracy or completeness of the report. One note, the FCRA requires that if the adverse action is based on a criminal record, an applicant's criminal record, the note must be in writing and specifically state that the decision was based on the criminal record. To put the requirements into context, the FTC's website, which I mentioned a moment ago, all includes press releases and copies of complaints filed by the FTC in federal court against employers who allegedly did not provide the notice of intent to take adverse action or the notice of adverse action, or both. Some examples of those press releases are a 2004 press release in which the FTC describes a complaint it filed against two casinos obtained applicants' consent to access their credit reports and graded the candidates based on their credit scores, then did not provide a notice of intent to take adverse action or a notice of adverse action based on the credit reports to the affected applicants. Employers in that case agreed to pay $325,000 in civil penalties in settlement of the suit, and those were two casinos that together paid $325,000. More recently, in 2009, two railroad companies agreed to pay $77,000 in civil penalties to settle a suit filed by the FTC. In complaints, the FTC alleged that the companies engaged a consumer reporting agency to conduct background checks, including criminal history reviews of job applicants. And according to the employers, the criminal record reviews were necessary. They were required by the companies, the railroad companies contracted with, to gain access to the rail sites. FTC's complaint, those companies did not provide the notices of intent to take adverse action or the notice of adverse action. Cases are evidence that if you're going to engage a third party to perform a background check, including obtaining a credit report, it's important to comply with all of the FCRA's notice requirements. Slide 18 sets out a really limited exemption from the FCRA's requirements. It provides an exception to the notice requirements if the consumer report is being used for an investigation of employee misconduct. Be a circumstance in which this exception is applicable to a pre-employment background check, but we applies more in the case of investigations into things like employee theft and other types of misconduct by an employer's current employees. Touched a few seconds ago on FCRA penalties. Employers who do not comply with the FCRA may face financial penalties. There are significant damages provided for in the FCRA, including actual damages, punitive damages, costs and attorney's fees for individuals harmed by a violation, and also other penalties that can be awarded to or imposed by the Federal Trade Commission. Moving from the FCRA to a Pennsylvania statute, did touch on the use of criminal record information in the hiring process as it's addressed in the FCRA. But a Pennsylvania statute, Title 18, Section 9125, specifically regulates employers' use of criminal history in the hiring process. The statute states that employers may not inquire into arrests that have not resulted in a conviction or records that have been annulled or expunged. Pennsylvania Human Relations Commission also chimed in this area and said that consideration of arrests that not resulted in convictions can lead to claims of disparate impact against certain protected classifications of individuals. The statute speaks to convictions as well. With respect to convictions, may request felony and misdemeanor conviction records only if the convictions are for crimes that are reasonably related to job qualifications. Like FCRA's requirements, this Pennsylvania statute requires that the applicant be informed if the decision not to hire is based on his or her conviction record. A Philadelphia ordinance goes a step further by prohibiting an employer from even asking about an applicant's criminal history on an employment application or during the first interview. And slide 17, Equal Employment Opportunity Commission has been pretty extensively in the not-too-distant past about disparate impact considerations and other types of potential discrimination that can result from employers' use of things like credit checks and criminal history checks. This slide discusses disparate impact considerations. Disparate impact is where what appears to be a neutral criteria has a disparate impact on protected classes such as racial minorities and women. Employers that do conduct credit or criminal background should make sure their practices do not give rise of disparate impact discrimination. And one way to do that, one way to avoid disparate impact claims, is to ensure that hiring criteria are job-related and consistent with business necessities, so that if an employer is going to conduct or review an employee credit history, it only review employee credit history where the credit history is relevant to the job the employee is seeking. Same for criminal record checks. Employer is permitted to look at an employee's conviction record, but should really limit its consideration or relying on the conviction record only where an employee has been convicted of a crime that is thoroughly relevant and related to the duties of the job the employee is seeking. The EEOC's initiatives relating to criminal background checks. The EEOC has issued specific guidelines that employers should follow when taking an adverse action based on the criminal history of an applicant. Employers consider the nature and gravity of the events for which the applicant or employee was convicted, the time passed since the conviction, and the nature of the job held or sought. Those criteria are not too different from the Ways Pennsylvania courts have applied 18 Section 9125 and the ways that other states have interpreted similar statutes. EEOC has also taken initiatives relating to background checks. The EEOC is concerned that the use of credit histories in hiring decisions may have an adverse impact on some protected classes, and that's actually been the subject of a public meeting in 2010 and various speaking engagements and trainings that EEOC attorneys have attended and conducted, both for members of the public and for, obviously, for training for EEOC attorneys. And the last slide of mine, and then I'll hand it over to Meredith, is more on the EEOC's initiatives relating to background checks. And this is not dissimilar from what I talked about a couple slides ago. And can take steps to minimize their liability to potential claims of disparate impact by limiting the use of credit histories to positions where credit information is actually job-related, developing clearly defined criteria to evaluate credit reports, such as number of accounts, number of delinquent accounts, etc., and providing applicants with the opportunity to explain their credit reports. In many cases, there may be mitigating circumstances. And Meredith is going to touch on some similar aspects or some similar employer policies that can be implemented related to searches of social media websites and internet searches of applicants' history. And we'll hand it over to Meredith.
Good afternoon, everyone. This next session is going to discuss the limitations on an employer's right to inquire into applicants' medical conditions and their medical history. The Americans with Disabilities Act provides a broad-based protection for job applicants and employees who have or are regarded as having physical or mental impairments that substantially limit one or more major life activities. With that, the ADA Amendments Act has broadened the definition of disability and the considerations that employers must pay attention to have increased with the Amendments Act. And as it applies to job applicants, ADA generally prohibits covered employers from taking adverse employment action against a job applicant or an employee based upon a known or perceived disability and from failing to make reasonable accommodations for such individuals. The EEOC has also issued guidance on this topic and analyzes an employer's ability to make disability-related inquiries or require medical examinations in 3 stages. The first stage is the pre-offer stage. The second stage is the post-offer but pre-employment stage. And the final stage of analysis is once the person is a full-time employee. The first stage, which is the pre-offer stage, is dealing with sort of the typical applicant, and ADA prohibits employers from conducting a medical examination or making inquiries of a job applicant as to whether such applicant is an individual with a disability or as to the nature and severity of the disability. And as you can see, a medical examination is defined as a procedure or test that seeks information about an individual's physical or mental impairments or health. Now, this prohibition on disability-related inquiries and medical examination applies even if the employer believes that those types of inquiries or examinations are job-related. So this pretty much is a blanket prohibition at the pre-offer stage. What exactly is a disability-related inquiry? And the EEOC has issued guidance and states that it is a question or series of questions that is likely to elicit information about a disability. The ADA's limitation at this pre-offer stage is meant to ensure that employers are not taking any adverse action based on an applicant's possible disability. Some examples that the EEOC has stated of these types of inquiries are sort of the obvious one, which is asking an applicant whether or not he or she is disabled or inquiring as to how the applicant may or may not be disabled. Another example is asking the applicant for medical documentation regarding a possible disability. And as a side note, that sort of question can also get you in danger under GINA, the Genetic Information Non-Discrimination Act, which prohibits employers from using any sort of genetic information, which is broadly defined: family medical history, genetic tests, certain clinical research tests, in any employment decision, which does include hiring. So that's definitely a question that you want to stay away from. Another example is asking about an applicant's prior workers' compensation history. So any sort of inquiries into whether they've been involved in any workers' compensation litigation, claims, or anything of that nature is also prohibited at this stage. The ADA does allow you to ask whether the employee can perform certain functions of the job. So, for example, whether the employee can lift a certain amount of pounds, if that's part of the job for which he or she is applying for, that would be permitted. You see with the second bullet point, the ADA does not protect current illegal drug users. So another question that you would be able to ask is whether or not the person currently is using any illegal drugs. Importantly to note, though, alcoholism and recovered drug addicts are protected under the ADA. So any inquiries into rehab or anything along those lines would be prohibited. And the next slide gives a little more specifics on that. So as you can see, you're allowed to inquire into the current illegal drug use. You can also ask about prior casual illegal drug use, but you can see, as the last bullet point makes clear, that there is a line that you should be wary of, and how often did you use illegal drugs, or have you participated in any rehabilitation program? They're likely to elicit responses that could indicate that the person is a recovered drug addict, which would make them protected under the ADA. And then dealing with medical examinations, the ADA does not limit when you can test an applicant for the use of illegal drugs. And as we mentioned earlier, the legal drugs are specifically excluded from the definition of a medical examination. You should be wary that if you do decide to test for illegal drugs of a job applicant, that it might reveal the presence of lawfully used drugs. And if an individual happens to be excluded from a job because you erroneously regarded him to be a current illegal drug addict, when the drug test revealed the presence of a lawfully prescribed drug, you might expose yourself to potential liability under the ADA. So just to be careful, again, it's a theme throughout this presentation that sometimes too much information isn't always the best thing. The next slide discusses more considerations on alcohol testing, and we're still in that first stage, that pre-offer stage, before you've made any offer of employment. And alcohol tests, unlike tests to determine the illegal use of drugs, are medical examinations because they are not specifically exempted by the statute. So tests requiring the drawing of urine tests, the use of a breathalyzer, those tests cannot be administered to applicants in the pre-offer stage. And that is also because alcoholism is considered a protected disability under the ADA. Now, while you may be restricted from administering these types of tests, you are allowed to inquire of the applicant whether or not they drink alcohol, and if for whatever reason you might suspect that they have drank alcohol during the interview, you certainly can ask, have you been drinking? But be very careful that you don't start a path where you might elicit questions that indicate that the person is suffering from alcoholism. And then on the last bullet point, you'll see some examples of fine line, which is how much alcohol do you drink daily, or have you participated in an alcohol rehabilitation program? Those questions are specific examples that the EEOC has given of questions that would likely elicit a response that could get you in trouble under the ADA. Now we are moving on to the second stage of what the EEOC will consider when looking to see whether an employer has a right to inquire and or test an applicant, and this is the post-offer stage. So at this stage, you've offered an applicant a conditional offer of employment, but before he or she starts to work, there's this post-offer pre-employment stage. And this stage is viewed a little bit differently than the pre-offer stage. And during this stage, an employer may ask a disability-related question and conduct medical examinations. But the employer must do this for all entering employees in the same category. So this is really important. If you do decide that you're going to ask disability-related questions or conduct medical examinations during this post-offer stage, make sure that you're doing it for everybody that's applying for that job position. Or if you have a policy, make sure that you uniformly follow that policy and always do that.
And if this is Bill again, I just want to jump in here and note, I know that we do have a number of public sector employers represented in the participant list, and we should note that the A requirements apply to everyone, but if you are a governmental employer, you're likely subject to much stricter requirements and guidelines than a private sector employer would be in the of drug and alcohol testing. So for those sector employers, we're happy to follow up with you. It would be, we could do a completely separate presentation just on the limitations on drug and alcohol testing for public employers.
Right. Yeah, absolutely. That's certainly a consideration, and there's actually quite a bit of case law deals with the right of public employers to test employees and sort of how the boundaries of the employee's right to privacy and things like that are more implicated when it comes to public employers. So just to finish up with this slide, employers may test applicants for current illegal drug or alcohol use when the applicants have received valid offers of employment. So again, their post-offer stage offers employers a little bit more flexibility in what they're allowed to inquire and what they're allowed to ask the applicants to do. A little more on the post-offer medical inquiries and testing. And here we talk about how an employer can deny employment to a post-offer applicant who refuses to submit to a test or who fails to pass a test, as long as all other applicants for the same job category have the similar requirements. So, and making sure that you uniformly apply your policies, and if you do decide to test, make sure you do test all applicants, because if it will be important, if your denial of employment is a challenge, to be able to show that all of the applicants for the certain job position were required to go through the exact same testing. And if an individual is screened out because of the disability, the employer must be prepared to know that the exclusionary criterion is job-related and consistent with business necessity. So it's important, again, that you're making sure that the reason that you end up denying employment to this applicant is consistent with your business necessity and job-related. The second bullet notes, again, alcohol is treated a bit differently, and information obtained from a post-offer alcohol test is subject to some quite different and strict limitations. More specifically, the ADA requires that employers who administer such tests maintain confidentiality of the medical information obtained from these tests, and to keep the results in files separate from other employment records. And along those same lines, access to the information must be limited to specific individuals or entities. So, the typical profile that everybody, even low-ranking managers, have access to would be insufficient and not in line with what the ADA requires for this type of testing. We'd recommend keeping a separate file for other types of sensitive information, which could include other types of medical information that you also wouldn't want to have in the employee's general personnel file. Current employees, this webinar is mainly focused sort of on background checks and what you're doing at the application stage of the game. So I'm not going to go into current employee medical inquiries, but just note that the limitations on medical examinations and disability-related inquiries of employees are more stringent than those affecting post-offer applicants. There are a lot that apply, and If you have any questions on that, certainly we'll be able to talk to you about it in more detail. But again, the ADA's limits on medical examinations apply to alcohol testing and not to testing for illegal drug use, as current illegal drug users are not protected under the Act. Now, focusing more specifically on Pennsylvania, there's actually no statutory provision governing substance abuse testing in Pennsylvania. However, the Pennsylvania Human Relations Act does define the term disability and not include, similar to ADA, illegal use or addiction to a controlled substance. Under the FCRA, alcoholism constitutes a non-job-related handicap, and as you can see, that's the definition of a handicap under the statute, and it is a disability which does not substantially interfere with the ability to perform the essential functions of employment, which a handicapped person applies for, is engaged in, or has been engaged in. So, in plain English, that means that alcoholism cannot be the sole basis for your decision to terminate an employee, or an employment decision which could potentially include hiring. Workers' compensation issues. This is sort of another layer that you need to consider when you're doing background checks and also inquiring into applicants' prior work history, medical history. You have to be particularly careful about asking about workers' compensation history when making your hiring decisions. The ADA does specifically prohibit the use of such information in making your hiring decisions. The EEOC considers information concerning an applicant's work injury record to fall within the scope of disability-related questions that are prohibited at the pre-offer stage, which I mentioned earlier. And prior to making a job offer, you may not obtain information about a job applicant's worker compensation claims or occupational injuries from third parties, such as former employers, state workers' compensation offices or services that provide workers' compensation information. And if that information is likely to come up in some sort of third-party search, again, as we talked about earlier, you don't want to be inadvertently obtaining this information for the reasons that Bill discussed, and then also under NINA, it can present its own set of pitfalls as well.
On this slide reminded me of something I should have mentioned earlier, and it may go without saying, but most of this presentation has covered federal law. The laws like the Americans with Disabilities Act and the Fair Credit Reporting Act are generally applicable across state lines. Agencies like the Federal Trade Commission and the Equal Employment Opportunity Commission have jurisdiction in all 50 states. Some of the laws we talked about, like the Pennsylvania statute governing the use of criminal history and the Pennsylvania Workers' Compensation Act, are specific to Pennsylvania, where Meredith and I are right now. But rest of the state you're in, or I would say many states have laws that are very similar to the laws Pennsylvania has, particularly those governing the use of criminal history. And if you have a question about your specific state, we're happy to follow up with you after the presentation.
Okay. Now we move on to sort of the last segment of our presentation, which is social networking. And not surprisingly, the legal risks in making employment decisions using various internet sources have become an increasing concern for many employers. And a primary reason behind that is that there have been a lot of studies lately, and I'm sure it's pretty wide known, that social networking sites are being increasingly used for hiring decisions by a variety of employers. As you can see on this slide, these are just some statistics that show that a large percentage of employers are using various types of internet sites when they're making their hiring decisions. There are a variety of advantages for employers in using social networking platforms. Our day and age, it's easy to hop on the computer and to Google someone's name and find out quite a bit about them. It's inexpensive and it's a sort of a less formal alternative to hiring a third-party agency to run a consumer report, credit report, background check, etc. It provides a bit of insight into an applicant's personality, particularly with the use of Facebook and Twitter. There's quite a bit of information that an employer gather about an individual from 3 seconds of surfing someone's Facebook page. Signs of judgment or embellished credentials. That's another reason certainly making sure that they're hiring the best people is of utmost concern to employers, and figuring out whether the applicant withheld information from their employment application, lied about certain credentials, posted confidential information about their prior employer, also engages in posting sexually explicit language, images, inappropriate material, bad mouthing. All of those things are certainly important to an employer before hiring an individual, and also might be readily available from looking online. It also might help provide employers, with their due diligence to make sure that they can avoid negligent hiring or negligent retention claims, which is always a concern. There are some dangers associated with the use of social networking platforms. As we've discussed, as Bill discussed, and as I discussed, federal and state laws prohibit employers from considering an applicant's race, religion, age, disability, gender, national origin, and various other protected characteristics. And as mentioned, we're focusing on federal and a little bit of Pennsylvania thrown in here and there, but there are certainly other states and further municipalities that have added classifications which they considered protected. So gathering information regarding these individuals' protected status that's readily available on social networking sites can be increasingly problematic. As you'll see in the last bullet point, some state and local laws protect against discrimination on the basis of sexual orientation and political affiliation, which is certainly readily available on social networking sites. And in an election year, there's plenty of blogging and twittering and posting about various, political parties and things like that. So it's really easy to come across this kind of information. And as you'll see, when the EEOC complaint alleges an improper background check, the employer might have to disclose whether it used a social networking site, and this challenge then becomes whether the employer can prove that it didn't use the prohibited information when making its hiring decision. And that's that might be an uphill battle if you did go online and look on Twitter and Facebook and find out all of this information about an employee and then make a subsequent hiring decision. And there are a lot of problems that can also arise just when Googling someone. So, even the more basic, not going on Facebook and Twitter and doing an extensive search, even Googling someone can reveal certain protected classification information. And it could also subject employers who are only going to these social networking sites occasionally, as opposed to in accordance with the policy, to some liability, because the way in which you go about obtaining this information itself might also be problematic. For example, if you're only conducting certain searches for some job applicants but not all job applicants, the EEOC might look at that with sort of a raised brow. Now, it's important to remember, as we've stated, that the Fair Credit Reporting Act and other related statutes do cover third-party investigators, and as an employer, you want to make sure that the companies that you're using comply with the FCRA, and also that you yourself comply with the FCRA. And one quick point, in addition to, and I guess briefly, when Bill was discussing the FCRA, on FTC's website, you can go to it and see there have been some recent articles that have dealt with certain third-party agencies that are sprouting up around the country that are assisting employers in obtaining helpful information to in terms of hiring. For example, if an employee is, you know, backing its former employer or something along the lines that might indicate certain characteristics that the employer is not interested in having, but also avoiding the protected classification information. These third-party agencies have been sort of targeted by the FTC and put alert that they are consumer reporting agencies. They're not just the third-party agencies that can go and compile information from Facebook, Twitter, etc., and provide it to employers without having to comply with the FCRA. So that's important to note if you happen to be using any of those third-party agencies, that those agencies will be considered covered. And then one other quick point is that there has been sort of recent concern, in addition to the FCRA and the FTC, that the NLRB has recently pursued companies for targeting workers that are posting on Facebook. And this can apply in sort of an applicant situation a bit as well, but it's something to consider if you are unionized or and you have union employees, that you need to be careful also when you're looking at these social networking sites.
On that note, Meredith, there are it's worth it to say, while we're talking about the application process, this is an incredibly hot topic in the labor relations arena, and while the NLRB has taken specific action, or I should say the board hasn't issued decisions specifically dealing with these situations, the General Counsel issued a number of opinions recently dealing with employee regulation of employees, Facebook posts, tweets, and other types of public comments about their terms and conditions of their employment. And we should expect this to remain an incredibly hot topic, both in the area of union animus or an employer's infringement on employees' protected concerted activity, also in the organizing context, actually organizing unions using social media, employer mail, and other types of electronic communications. So this is definitely something to keep an eye on.
So that we've told you about all of the potential pitfalls that employers might fall into, what can you do to protect yourself and your company against potential liability? And here are some recommendations that we have. And the first is probably one of the most important, which is to establish policies and procedure for the use of electronic social networking sites in hiring decisions, and make sure that you uniformly follow these. These policies should contain what information is going to be evaluated when looking at social networking sites, and keep in mind that these social networking sites don't always contain the full picture. So in drafting your policies, those are the types of considerations to keep in mind and the types of information to include. The second bullet, read the terms of use of the site to make sure certain uses are not barred. This is separate and apart from any other statutes that we've talked about, but certain social networking sites might have their own restrictions on how you can use their information. So you might inadvertently find yourself using information unlawfully. So it's important to check the terms of use on whatever sites you plan on searching and using. And the next bullet point, be consistent in the use of social networking sites. You shouldn't use certain internet searches for consumer reports for only some candidates, not all, and only use some sites for some candidates and then other sites for others. And it just sort of raises suspicion in why you're choosing the sites you're choosing for the people you're choosing those sites for. So, and you be uniform in your policy and be uniform in the sites that you choose to use as part of that policy. Another recommendation is to have a non-decision maker conduct the search and filter out information about protected characteristics before sending information to the decision maker, particularly if you perform the searches in-house. This is an option for you because this way the person who's ultimately making the decision does not have any access to whether what the applicant's race, religion, age, age, disability, etc., may be. So that is another option. It's also important, though, to educate your managers and supervisors on your company's social media policy on screening applicants, because you don't want to have a supervisor who might ultimately be part of the decision-making process get the applicant's application and say, I'm going to go ahead and just do research before she comes into my office. Go online, do a Google search, and all of a sudden she's now had access to potentially protected information, and she would be part of the decision-making process, which could compromise the employer's position in the event that their decision is subsequently challenged. And always important, document everything. Your paperwork and your procedures are your first line of defense to help you show that you used a legitimate non-discriminatory reason for making your employment decision in the event that it's ever challenged at the agency level or later in court litigation. So those are some suggestions. Certainly, as Bill and I hinted to, this is such a broad, hot topic that kind of touches on almost every single aspect of what we do. So certainly we're happy to field questions. Bill?
Actually, there was one question that came up that was that seems to be related to what Meredith's talking about right now. Asked if a check of Facebook is a consumer report, does that make Facebook a consumer reporting agency, which is a really interesting concept. I think the answer is no. Facebook's not, the employer's not asking Facebook to provide any information. And as I said earlier, if the employer is the one doing a check of an employee's Facebook account or MySpace account, it's not a consumer report and not subject to the FCRA regulations. These agencies that have popped up that the FCC is pretty concerned about, that the employer a favor of looking at employees' Facebook accounts, tweets, and other types of publicly available information. I think the benefit of an employer using those agencies is that the employer will not gain access to information on an employee's personal site that the employer doesn't want to know. If you're an employer in the interview process, you don't want to know about an employee's disability status, sexual preference, family status, age. Those are things that are essentially off limits in most jurisdictions during the interview process. For reason, the ADA regulations prohibit, pre-offer drug testing. And Elizabeth asked if an employee tests positive for a prescription drug during the pre-employment phase, can the employer require evidence of the prescription, and if there's no prescription, refuse to hire? The reason for the ADA's regulation is that employers should not, the employer doesn't want access. Well, the reason for the caution against pre-offer drug testing is that employers can find out information that they don't want to know during the pre-hire process. And that's a good example, an employee testing positive for a prescribed drug. The employer should not base the employee's decision to hire or not on an employee's use of prescription drugs, unless the use of prescription drugs is specifically related to the employee's ability to perform the job at issue. And that's a determination that is most safely made after the employee's been made a conditional offer of employment. So this is a lot of information. No, we're coming up on noon. We're not going to have time for any more questions. We did receive a couple of other interesting questions, and we'll try to get in touch with the people specifically, the specific people who asked. But as I said at the beginning, on this final slide is our contact information. Please don't hesitate to call us or email us if you do have questions about any aspect of the presentation. And